Welcome to the We Win Injury Law podcast, everybody. I'm Tyler Todd, your host, sitting here with my co-host, Jaren, the Snow Canyon Man Sandberg. Good morning.
Good afternoon.
Yeah, I knew that was coming. I almost gave it to you.
If you don't give it to me, I'm going to give it back.
I was like, it's 8 a.m., but a good afternoon might be warranted.
Yeah, no, good morning. Good morning, Tyler.
Good morning, everybody. This is kind of a hot topic that we're talking about today. And it's a super sensitive one, and it's, again, in our backyard. Yep. National news, on all the headlines, and it's in our backyard. Yep. Again, what's going on? What are we drinking in the water in Washington County, Utah?
Washington County's got something.
We're talking about the Parker, is it Kingston story? The new allegations of, and it's not just, well, there's a number of factors that make this like headline news, right? He's a star wide receiver at BYU.
Who had a big year.
They had a great year with their football program. He had a great year individually. It's BYU, so Brigham Young University.
So it's an overly religious school with a honor code and
strict honor code. And we can dive into that about, you know, their admission process, like so many kids that are LDS Mormon kids get rejected every year, thousands upon thousands. Yep. And then we'll get into that. So strict honor code. He was previously engaged just days before this all like hit the fan, right?
3 days before.
And not just engaged like these kids today that are like posting everything on social media, but he did it. I think he proposed like at a basketball game, I think at a BYU basketball game or something. It was like super highlighted. Is that right? Do you know? I think it was like super highlighted, like a big deal. So there's just a number of things that just kind of like, and then of course, and we'll get into this, like a year-long investigation. So, pretty wild story. Washington County, Utah, BYU football player alleged with, is it first degree felony rape?
Yep.
Sexual assault. Is it sexual assault? Or, no. So it says he was arrested and charged with first degree felony rape. Yep. And the charge stems from an alleged sexual assault reported by a 20-year-old woman who says the incident occurred this month, last year, in St. George, Utah.
Yep.
It's almost a year today. Wild. And then it looks like law enforcement have been conducting a year-long investigation, including collecting digital and forensic evidence and interviewing a number of witnesses. So it's really interesting because we know a number of these individuals that are investigating this case, that are prosecuting this case. I know the lead prosecutor, the Washington County attorney. You know him.
Yep.
Good guy.
Yep.
Good attorney. Very, very, always a reasonable, very fair prosecutor over the years. We've known him and worked with him in the past.
Yeah, I felt fair. And some of the prosecutors we've been frustrated with over the years, but I felt like he was one that straight shooter would be my...
Well, sometimes, and I'll say this, we don't do criminal law. We haven't done it for a long, long time now, but we did it years ago. Sometimes I felt like, and I don't know if attorneys around the country feel this way, that do criminal defense, but I feel like sometimes the prosecutors will overcharge.
Yeah, especially in state court.
Like tremendously overcharge, and then like they'll come off that charge and then give a plea deal.
Yeah.
And then it seems like they're being magnanimous. We're giving this great deal. I'm like, you overcharged it to beginning.
Now you're just back to what it should have been charged with.
Originally. Yeah. Because you didn't really have the evidence and the probable cause or anything to substantiate the original charges. Yeah. I'm not saying that happened all the time, but it felt like it happened occasionally.
Happened a lot.
It happened a lot.
Well, the misdemeanor court stuff, and DUIs, they charge as DUI. It wasn't like
that's easy.
That was pretty easy. But like we had a case years and years ago where we had a homeless man in the middle of like a rainstorm at night in the dark or early morning get hit by someone who had like marijuana from like a week before in their system. It was like the most, and the guy was forthcoming at the scene of the accident. And I remember they charged it with like felony manslaughter or something stupid. Like the charges were way over the top.
Yeah, we went back and forth.
So even on simple charges, they can still go over.
And it's a balance, right? It's a balance between, protecting the public interest versus, what the evidence shows. Hey, we have enough for this charge. I mean, it's hard because they're in a hard position. They're kind of between a rock and a hard place, right?
Yeah.
If they undercharge it, then they get scrutinized. If they overcharge it, then the defense lawyers get mad. And who ultimately, who are they protecting? So...
Well, in plea deals, we talked about this in a previous episode with the Idaho Koberger case. You're not going to make either side happy. Some of the family was glad to have it done and that he didn't have to do this trial. And the other part was like, I wanted to see him go to trial and be hanged for this.
And the evidence, we haven't done a subsequent podcast of this, but the evidence that's come out and the photos that have come out, since with showing him basically on scene and it's pretty egregious.
Yeah.
So it is interesting, even amongst the victims' families, how they were all kind of, they saw it differently, right? Mm-hmm. And justice to them kind of meant several different things. So Parker Kingston here arrested, and then bail has been set by Judge Walton. Judge Walton is also, we've been in front of Judge Walton numerous times. Fair judge. Good.
Very fair judge. And I've had, I'll give you an experience. This is going back about 11 years ago. It was one of my first hearings. And I had a client that was really pushing an issue that I think from a legal standpoint with very low chance of winning. It was in a family law dispute. And I remember Judge Walton pulled me into we did an in-chambers review. And he goes, Mr. Sandberg, I appreciate the briefing. This is really well done. But I'm not going to overturn 30 years of precedent on your case. But I can go out and give both parties a nice stern warning that they should work together and cooperate. And I feel like he did the right thing, even though the law maybe didn't support my position as much. And ever since then, he earned a little bit of grace when I've been in front of him from my court because I felt like he was a balanced judge.
Yeah, and the misconception with a lot of people before they go in front of a judge, especially as per, meaning like they don't have a lawyer, is they feel like they can go up and give like a sob story. And a lot of the sob stories are legit, right?
Yeah.
They feel like they can go give this sob story and the judge is going to hear them out and just kind of like, oh, I feel sorry for you. That's not the role of the judge.
Yeah.
They typically can't do that. Now, there are times if they can give there's a little leniency or something.
Well, he gave a stern warning and then ruled against me. So he still did the right thing.
But yeah, the judges can't do that. Judges have to follow the rule, follow the law, and even though they feel bad for you, they're going to say, I can't, that's just not the law, and good luck, right?
Yeah.
So, in this scenario with Parker Kingston, right, apparently the evidence was significant, or is significant, enough to warrant $100,000 bail, okay? On its face, it seems like a lot, right? So when it hit all the media and news outlets, it's like $100,000 bail for this BYU football player. That seems excessive, but in all reality, he's going to bond out on $10,000, and it's not that big a deal.
Yeah, and so for people listening that maybe don't understand the bail system, there are some times where they'll allow, where they won't allow a bond. They'll just say $100,000 cash only.
Cash only, yeah.
And so and when they make a ruling that's cash or bond, it just feels like, okay, it's not really $100,000, it's $10,000 because that's what you'll pay to a bonds company. Now that's normally not refunded unless someone puts up their own house or does something outside of that. But if you use a bond company, that's their fee.
Right.
10% fee. Okay, you pay us $10,000. We put up the $100,000 bond, which is just a piece of paper, like an insurance policy almost, and they submit it to the court. And then if that person then skips court, flees the country, that bond company is then responsible for getting him back to court so they don't lose their $100,000 bond.
Right, and they'll get it back more times than not.
99 out of 100. And normally it's just tracking down the person died, or I had a neighbor, Bonnie Nielsen was her name growing up. She was a Bond woman. I don't know if you ever met her, but
I don't remember.
But I think she worked for AAA. But anyways, the bounty hunters used to come by the house every once in a while picking up files because she just worked from home. And I remember thinking that was kind of an interesting job. That like this sweet woman who's maybe 5'1" or something. She's a very small woman. And then these guys, in kind of Kevlar.
Yeah.
Okay, we think this is where he is. We're going to go do this operation. And
she's like, go get him, boys.
Go get him. These bounty hunters for people skipping bail.
Yeah, so this tells me, like, okay, it's not the most egregious. It's not a cash-only bond.
Yeah. It's
not the most egregious, like, bail. It's actually, for the charges, pretty typical. It seems pretty standard.
Yeah.
Which,
We had a speeding case a few years, this is going back 8 years ago. Remember the kid on the bullet bike flew through? Right. I think his was $100,000, $10,000 bondable, and his dad bonded him out.
Right.
So not the.
Yeah, and I think a lot of people look into the bond or the amount.
They see 100,000, they think that's a lot, but it's 10,000.
Right. But on the flip side, I think a lot of people see that and say, oh, that's not that big a deal.
Yeah,
and so now he did order GPS tracking and an ankle monitor.
Yeah, so the two considerations for bond that the judge is considering at this stage is they haven't weighed the facts. That still happens at a different hearing. What they're doing is instead they're looking at threat of the community and the chance to reappear, right?
Yeah,
Are they
flight
going
risk.
And flight risk. So with those two considerations, and you have an ankle monitor that as soon as you start tampering with them, they even go off now.
Right,
They're pretty sophisticated. I think most judges at this point, you're pretty secure that,
right?
And the prosecutor can always revisit bond if there's if this was like a foreign student or something that was here on a visa, bigger flight risk, right?
Sure.
And so they have those things they can consider. Other criminal history, they take into account criminal history. So if you have past criminal history, well, that might not come in at trial. That at bond hearings, that definitely comes in. So they look at all those things.
And a no contact order, which is fairly standard in these types of cases.
Now,
so he can't
was
contact
interesting.
the victim, and can't come in. Now, so he can't come into Washington County. He's got to stay outside of the county because the victim is here. So he can't come into Washington County, but for appearances.
Yep. Did you? Well, the one thing I thought was interesting was they told him he had to delete his social media accounts, which almost felt like me and you always deal with in the civil context, like don't delete anything.
Right. Yeah. I mean, maybe only for like to avoid public comments. Hey, we got you, or we got your back, or you didn't do. I don't know. Stay strong.
Or to sleuth who the victim is based on social media.
That could be
maybe that was it. They're trying to protect the victim. I don't know.
The identity. Yeah, that could be it.
But it seemed weird because normally we're so focused on preservation letters and don't destroy the evidence. And if there's something he said in the social media account. So that was kind of an interesting order.
Well, and then the judge, and this is a little interesting. I found this interesting, to be honest.
Yeah.
That Judge Walden said there was clear and convincing evidence that the defendant posed some risk. Now, that could just be like based on what was presented.
Yeah.
It just seems like that was kind of a statement that, I don't know. So if this goes before a jury and a potential juror hears that, are they already like somewhat tainted that there's clear and convincing evidence that there's guilt?
Well, and this is where it's so hard that me and you talk about this a lot, is like we still, for all intents and purposes, live in a very small feeling community. I mean, I know Washington County's grown a lot, but it's a small community. It's a small state. I mean, we're very interconnected, and more so on social media, that I'm like, how is a potential juror not going to have seen all of this? You just have to find like that person that like lives in a trailer and has no internet. I mean, I don't know where you're going to find someone that's
the jury duty.
Like, how do you find someone that's completely unbiased and has not heard these statements circulate in the news at this point? We just live in such an interconnected world.
Yeah, and I wasn't in the hearings. I don't know exactly what was said. I just those types of things, if those are like being said, or at least they're being misconstrued, to me, are better saved for, I don't know. Maybe you just don't say that.
Well, and maybe that's just the standard he has to find for a bond amount is he has to just say that like the standard for what's required from the probable cause statement or something.
Just for the set bail and to bind him over, right? So but they haven't had a preliminary hearing yet.
I know
so there's been no preliminary hearing to at least say, hey, there's been sufficient evidence to bind him over for these felony charges. He's just been arrested. There's been a bail hearing. So you guys watching at home, really nothing substantive has really happened. There's just been enough to find that he poses a substantial risk to the community to set like a bail amount, and then there's going to be a preliminary hearing set because he's being charged with felony, or at least I don't know how many exactly felonies, but at least one.
Yeah.
So
in Utah, we don't convene grand juries to determine if they bind over, like in the federal system. In some states, they'll convene a grand jury. In Utah, we just do a preliminary hearing. The judge makes that call.
Now it's a lesser burden. The burden, it doesn't have to be beyond a reasonable doubt like a trial, but there has to be at least enough a preponderance of the evidence to suggest that the charges are warranted, and to bind him over for that type of charge and go through the whole trial process. So I don't know. It's interesting. I think the preliminary hearing has been set in April. Yeah. Now, sometimes I don't know how they do it nowadays, but many times those hearings will be waived, meaning the defense lawyers are like, and they've met with the prosecutors. They have a lot of the evidence. They've seen a lot of what
is likely going to be presented.
And then they agree to waive the preliminary hearing because they just say, hey, there's enough. Yeah. And let's not go through that process. Let's get down the road and let's start really getting to trial type setting or talking agreements. But these charges are so significant, they might have to try this case.
Yeah, and it's interesting on kind of the charges here because when you make such a media spectacle of it, like, me and you dealt with a few cases over the years. One of them that comes to mind was a dog case. I don't know if you remember this one, but we showed up and this was like misdemeanor court. This was pretty, supposed to be kind of small potatoes, and KSL News and ABC was there.
Right,
do you remember this?
With the shears.
A gentleman had, at least as he had told it to us, and we didn't get overly far in this case, but little dog had come over and basically was yapping around his granddaughter, if I recall, grandson or granddaughter, that was just an infant, like on a blanket out in front of their house, and he's cutting some shrubs with some shears.
Yeah, but to his credit, to his defense, right, this dog, even though it was small, was
coming toward
the baby and aggressive, and it doesn't take much.
Yeah, and I remember him just saying, we met with him a number of times, and I think you met with him more than I did, but I remember him just saying all I was doing was kind of shooing the dog, and the dog kind of jumped in to the shears at the same time he's kind of shooing this dog, and killed the dog. Dog died, which was sad. And
sad.
Little girl was sad with the social media uproar.
Obliterated him. Now, and this is where it's frustrating. I've seen enough dog bite cases with little girls' faces to know that it doesn't take it happens quickly.
It doesn't have to be a big dog.
It doesn't have to be a big dog, and it can change a little face forever. So I can understand where he was coming from.
Yeah.
But he got annihilated.
In the court of public opinion, at least. And so for us, a little bit of it was, I remember we kind of continued some things, and I think even the prosecution kind of acknowledged, like, hey, look, there's a lot of media attention on this because this Facebook story had blown up. Let's let this kind of blow over before we talk plea negotiations. We took some time with it.
Yeah, the strategy part, let it die down a little bit.
And so in this case, what's going to be interesting, the ankle monitor brings up a funny story. And, if you recall this is one of the first cases I remember you assigned me just an issue. What it was is a client had come into the office, and it wasn't the U.S. Marshals looking for him.
It was, the FBI, it was pretty wild. This also had national coverage.
Yeah, and so walks into your office, hey, they're looking for me. They've arrested a bunch of people. They're looking for me, and think you negotiated his surrender with the local field office at the FBI or something. Anyways, the case ended up going national, and our client, was on what I'll call the edges of that case. But the main person in that case had a defense attorney, if I recall, from up north. It was a woman, and at some point cut his ankle monitor.
Yeah.
And I remember at the hearing, I think, and again, you'll correct me if I'm wrong, but as I recall the story, and you'll have to fix it.
It was the lead defendant, but it was also the brother of Warren Jeffs.
So, Warren Jeffs.
So it was kind of a big,
at least for Southern Utah, it was a big case. But I think the prosecution made some argument like, "Hey, why can the lead attorney still be making, positions that her client isn't here to make?" And he's skipped his ankle monitor or something like that. And if I recall, this is what made the national headlines. That was funny. He said, "Whoa! We don't know that he cut his ankle monitor." And I think it was olive oil was what he had used. I think it was covered in olive oil, if I recall. But he said, "We don't know if he was kidnapped. We don't know if he was, stolen in the night, and we also don't know that he didn't experience the rapture." And that was the part that made national headlines. Was defense attorney argues that client may have experienced rapture.
I mean, it's a good argument. You never know.
Now you knew her. Was she just joking?
I mean, it was a little tongue in cheek.
It was tongue in cheek, yeah.
But I mean, they are very religious individuals, so you never know. And
we got a lot of interesting material in that case on the question of bond. If you recall, it was kind of a lot of kind of LDS church document style stuff. Anyways, it was really
dealing with many of them were FLDS individuals. Interesting, very interesting, because just cultural beliefs, religious system, and that was part of that's why I was a bit tongue in cheek, but also to some degree that's like they really believe that stuff. So
yeah,
and who are we to question whether there was a rapture or not?
Yeah, did they catch him? I never actually remember what happened. They caught him later.
But yeah, I mean, it's just interesting because when you deal with like these highly religious types of schools like BYU.
Yeah.
Apparently, then they've come out since, and said that he's no longer a student.
It's a violation of the honor code.
And so that's it's just it's so interesting. It's super sensitive. One thing it does highlight is that regardless of who you are, hopefully the legal system kind of always just kind of follows its course, and they follow just hopefully tried and true processes. And our legal system isn't perfect, but it's all we've got. That's the criminal system. We work within the civil system. Judges make mistakes. Prosecutors make mistakes. Everybody makes mistakes. It's not a perfect system, but I think everyone's trying to do their best.
Yeah.
And it'll be interesting to see how this case ferrets out, over the next little bit. It's unfortunate for both families. It's unfortunate for it's kind of just casts everybody to the school to some degree in a negative light. That's probably why they have to distance themselves and say he's no longer a student here.
Yeah.
Because then you question the honor code, you question the admission process. Like I said at the very start, you're like, wait, what's going on? Like, so many kids that are good kids want to get into BYU, and they're excluded for either grades or honor code, or stricter standards.
Some people don't know is that you meet with a bishop and you have to get, I think what they call it, an ecclesiastical endorsement. You have to get all these things, and so then you're wondering, like, there's a part of me that, at least outside looking in, and again, I don't know the process, were people aware, but then gave him a pass because he's a big football player.
Yeah,
and it could be the opposite.
It could be the opposite. I'm not saying that happened.
We don't know that.
We don't know that, but you just kind of all those things. There's all these question marks, which again, makes this an interesting case, and it's for all all the players involved. It's super interesting.
Yeah, and
for the school,
and for the victim in this case. And again, it sounds like the allegations were made long ago. That it was at least what was reported was a years-long investigation. For her, while all this is going on, to see him getting national attention and big media, probably re-traumatizing to some degree on what she's alleged. And
yeah, and so for all those reasons, it's a very sensitive matter, and the legal system has to kind of work itself out, and it'll be interesting to see how that goes. But
what it does remind me of is makes me glad we're in the civil world. And not doing that anymore.
Well, we'll certainly update as we know more. It's just interesting, again, in our own backyard. This is another high-profile case that we're dealing with, and knowing many of the players involved. It's just super interesting. So thank you guys for tuning in. Like, subscribe, share. It's super helpful. We appreciate it. Hopefully this has been entertaining and informative. Yeah, it's so hard to say entertaining. Like, I don't want to be entertained by
you can be entertained
so
by the
sad.
rapture story.
The rapture. But it's sad because so many people. But anyways, thank you guys again. Until next time, everybody, leave early, slow down, stay classy, just be kind and considerate to all those around you. That's the most important thing.